the Joint State Government Commission put together a very, very thoughtful and excellent proposal. They mimic the Connecticut model, which is and it's used by more than Connecticut, which is a services model. I like that model also as an amalgam with everything else we're talking about. Now, we've used services in Pennsylvania for years. Almost every county has educational programs, mandatory educational programs for people going into custody. That's a service. A lot of counties have mandatory mediation, although some don't have mediation. They just call it mediation. But that's a service. In very recent, one of the great new services that's hot out there, and Superior Court's addressed it twice, we haven't addressed it, is parent coordination. And that's a third party to make some of the minor decisions to keep people out of the court. I think that's not as good a model as a parenting plan with a dispute resolution system unless the family do it. It's a better model than having the court do it. There's all sorts of other services that are available. Anger management classes. Relationship classes. If you have had a drug problem, you have a mental health problem, those services are obvious. The services are sitting in every one of our counties. They're in child welfare, and they're in juvenile justice to a lesser extent. A high conflict custody case puts a child at the same risk, in my view, as a dependency case or even a juvenile justice case. And so those services can be borrowed for as short a time as possible, using the particular service most necessary to get the parents over the hump of high conflict. And instead of using the court system, which exasperates it, use the model to reduce it. And the hope is that pretty soon, 6 months from now, 8 months from now, they'll be able to start parenting. And when you get that good cycle going, it perpetuates itself. So that's what we want. In addition to Connecticut, which is famous, Arizona, which is a progressive jurisdiction, Florida, are all using a model of the services provision. And I think that again, is an important component to trying to reduce stress. So, in conclusion, very quickly, we think best interest can work, but we think it needs to be more anchored to specific criteria. We think presumptive joint custody is not the right answer. It's been shown not to be the right answer everywhere that it's been tried. I think the approximation rule is a wonderful rule to help the child get through the trauma of that initial separation. Then we think we should energize parents, use parenting time guidelines, and get parenting plans. And let parents figure out how to raise their kids and not have the state raise their kids. Use services that are available in every county in Pennsylvania already as necessary and appropriate for as short a time as possible, using the laser to get to the right service so that the parents don't become codependent on it, but we ease them through. I want to make a comment on a few very quickly on a few separate issues. Modification of litigated custody orders. Before 1988 in Pennsylvania, you had to show substantial change of circumstances to get back in court. My court, obviously before I was on it, or I would have been in dissent, my court, in a case where parties sought to go from partial to shared custody, pulled the language from the parent and child, the Grandparent Visitation Act, and said, well, you can do that at any time. You don't need substantial services. And that language remains verbatim in Act 1649. And I'm sure the drafters were not aware of the case law history that was there. Then my court, and there was a strong dissent by Chief Justice Nix. Then my court compounded the error in a case, Jandil versus Myers, 1989. It was a pure curiam order. It was a one-sentence order affirming the lower court. But there was a footnote to the order citing Karras, which was the shared custody case, saying that we see nothing in the legislation that says that there must be substantial change of circumstances. So any party can seek modification of any order, even the one that was decided yesterday, at any time. I think that should have a legislative response. I think we should go back to substantial change of circumstances, because I don't think the courtroom is a good place for the kids and to the parents. The other thing I wanted to mention, final topic, I think, is relocation. And one of these statutes deals with relocation. I commend that statute. What it says is give notice. But I wanted, again, to share with you that around the United States, you have pro-relocation states, Mom, you can get up and go with the kids. You have anti-relocation states. Kids are young for a very short time. Stay here so both parents can be involved with the children. And then you have states like Pennsylvania. And ironically, this again came from a case, Gruber versus Gruber, that the Superior Court decided. It adopted Donofrio in New Jersey at about the same time the New Jersey Supreme Court was overruling Donofrio. It's not working very well, but we've had it for almost 20 years in Pennsylvania. And that's sort of a neutral let the judge decide. Again, I must tell you, I speak only personally from my own experience. I am an anti-relocationist. And the father groups are probably like that. I am an anti-relocationist. I think kids are young, and when they get to be 12 or 13, they want to be with their friends. They want to play football with summer practice, or band, or cheerleading with summer practice. I think you got married, or you had children together, and you should stay together for the very short time that kids grow up. And I recognize that if you're in high conflict, we're keeping you together, but I want to solve high conflict by constructive means and not by having somebody move to LA and somebody stay in Pittsburgh. So I am not in favor of relocation. Finally, in one of the bills, and I was going to talk about the bills and sort of got lost and didn't, there's a suggestion of contempt for custody. I absolutely agree with that, and I think you should say that explicitly. I think, again, I don't mean to make this about fathers groups or mothers groups, but fathers groups have a legitimate right. They don't pay their child support, and we throw them in jail. They go to pick up their child, and the door is locked, and we don't do anything. We should treat the right to see your child when it is met by the other parent's obstructions just as seriously as the right to pay child support. And we should use law enforcement, and I promise you, if we put mom in jail for an hour or 3 hours, a couple times, we'll get rid of the problems. The problems are exasperated because there is no enforcement activity when it comes to custody. I want Sandy to say something, and we want to take questions. And again, as I said earlier, I know I went through an awful lot of material as to what a custody system, if I was writing on a blank slate, might look like. I'm available to any of you by telephone, by email, at any time. I'll come back to Harrisburg for any time, in public session or in private session. And I'm willing to do anything to try to enhance your obligations. And finally, these are all your calls. We don't make public policy, we follow it. So try to give you the best advice you can. Whatever you come up with is okay. Well, it may not be okay with us, but we'll follow it and we'll enforce it.
Good morning. Thank you again for allowing us the opportunity to come speak with you. I just have a couple of observations. I know the chairwoman talked about my position at the Administrative Office of Pennsylvania Courts. I'm the administrator of the Office of Children and Families in the Courts, which was established just a few years ago. And my focus has been exclusively helping abused and neglected children, working with dependency courts and child welfare agencies across the Commonwealth. But looking and working in child welfare, I have some observations about what's obviously happening in custody, because as Justice Baer alluded to, when you get into the high conflict custody cases, often some of the same dynamics we see in the child welfare arena. So I think the first observation that I wanted to share was that I think every one of us in this room has either heard, will hear, or has lived through, either as a child or as a parent, individual scenarios of situations where perhaps justice may not have occurred in the manner in which that person would have liked it to occur. Partly, I think that comes down to the human factor. We have individuals stating their case and other individuals making decisions about those cases and the statements that are made. But I think just as we do in child welfare, policy shouldn't be driven by individual scenarios or individual cases. Certainly those help inform us as to what we might want to look at, but they should not be the foundation for policy. I think the foundation for policy in child welfare and in custody is looking at the science, looking at what is working to help children and help families across the nation and internationally, and then applying those practices. And that's really what we've done in dependency courts. We scoured the country, we scoured the international evidence that showed what seemed to work best for children who were abused and neglected, and we brought those practices to Pennsylvania. But we brought them to Pennsylvania in a very unique way. We gathered